Hello everyone, this is Jitender Chaudhary, Assistant Professor IPM College Ghaziabad in Department of Commerce. So today I am going to deliver a lecture on types of contract which is part of your business regulatory framework in BCom honors third semester. So before moving to the types of contract, first we understand what do you mean by contract. So contract is basically an agreement which is enforceable by law and which have certain essential element. So if we are creating a contract, the both party fulfill these kind of elements. So these elements are include, first is your, basically we have certain elements where you have to be fulfill these elements. First is your offer and acceptance. If uh, that doesn't matter how many parties are there, they have to first party will offer something to another party and another party will accept the their offer. So first is your offer and acceptance, then we have the intention to create legal relationship, right? So when we are entering into a contract, there must be a thing that you have to create a legal relationship between their whatever the parties are involving over here, right? Then we have the lawful consideration where third party essential element which is a valid contract in the presence of the consideration. So consideration has been defined as the price paid by the one party for the promise of the other. So the consideration must be legal. We have to pay a certain amount, we have to pay certain things, but it must be in a legal terms, right? Now another point is capacity of parties. The parties which have the majority age and they must have the sound mind, and the party which do not disqualify by the law. And another one is free consent. If you are entering into a contract, there must be a free consent from the both side. If someone you are creating a contract by the coercion, undue influence, misrepresentation, fraud, these kind of contract made are void ab initio, and we have to be voidable at the part of the deceived party, right? Moving further, we have a lawful object where the formulation of the valid contract is also necessary, and the which have the public policy must be there, and they do not supply the things which is prohibited by the government. Suppose you are supplying a drugs or you are supplying pistol to the public, these kind of object cannot be considered in this. Further, the writing and the registration, the contract which you are entering, this must be written in the registration, right? And the possibility of the certainty. If someone is offering that that is not possible, which cannot be form a contract. So certainty must be there, and the possibility of performance must be there. So if the possibility is not there, we cannot say this is a valid contract, right? Now we have different kind types of contract where the on the basis of that contract has been generated. First is your on the basis of creation, and second one is on the validity, then the execution, and the on the basis of liabilities. So first we understand the on the basis of creation. So in creation, we have the five contract. One is your express contract, implied contract, tacit contract, quasi-contract, and your e-contract. On the basis of validity, we see the valid contract, void contract, voidable contract, enforceable contract, illegal contract. On the basis of execution, executed contract and executory contract, and we have the partially executed and the partially executory contract. And last one is your on the basis of liability, where we have the bilateral contract or we have the unilateral contract. Now further we understand the on the basis of creation. So First, here is we have the express contract. In express contract, the parties if come into the contract by word spoken or oral contract in written. These kind of contract, if you are making these kind of contract, this come under the section 9, which says the proposal or the acceptance of the promise made in words and said to be expressed. So these kind of contract are known as your express contract. If we further move to the implied contract are the contract where the offerer is offer something and it's up to you the offeree want to accept it or not, right? So by the implied means that is law implied on a contract through the parties never intended according to section 9, so that such proposal and the acceptance may be otherwise than the words. Let's say I'm giving you some example. If you are standing on a bus stop and bus is come to your side, and that is up to you, you want to take the services of bus or not. If you are take the services of bus, you have to pay certain amount. So these kind of contract made by your implied contract. Now the contract which is come under the category of tacit contract, basically these are the referrer contract where the machine are involved. So if you are withdrawing cash from the ATM machine, this is the contract where you are creating a tacit contract, right? A sell by the fall hammer of the auction sales. So these kind of contract come under the category of tacit contract. If we understand the quasi-contract are those contract where these contract neither the word is spoken nor the written nor by the conduct of parties, but these created by the law, where the party is bound to perform their duties. So these contracts are basically made by the law and you are bound to perform their duties, right? So let's say take one example. If A leaves his goods at B's shop by mistake, then it's the duty of B to return back the goods to the A. If he lost the goods, B must be compensated to A. So whatever the cost of the goods have to pay them, right? Now the last one is your e-contract. We saw that we have come under the category where the through the mails, through the fax, through the telephone, these contracts are created by the your e-contract, right? Further we move to the on the basis of validity, that is your valid contract. And valid contract an agreement which satisfy all the requirement prescribed basis of creations, right? We have already talked about the basic elements of the valid contract. So these kind of contract must be performed where the all the elements necessary elements has been already required, right? If we further move to the void contract, these kind of contract are basically you know void when the ceases by the law. So when the both parties in agreement are under the mistake of fact and maybe come under the category of consideration of the object, unlawful object may be there, or the agreement made without consideration, or agreement in restraint of marriage, restraint of trade, and we have some legal proceedings. Suppose you are you know there is something in a public and you are removing that things and you are damaging the public properties. This come under the category of void contract. Further we move voidable contract where the option of the one or more party but cannot option on the other party. Here is one is your deceive party and one is your agree party. So basically the deceive party have the right to sue in the court or not, right? So another we have the unenforceable contract where the contract goes in substance, but the technical defense must be there. So we can say this is your unenforceable contract. An agreement which is require a stamp is be unenforceable if same is the not stamped, right? Further move to the your illegal contract. It's a contract which is law forbidded, or the all the illegal agreements are void, but all the void agreements but contract are not necessarily illegal. So contract has their immovable suppose, and we have the public policies and the natures. So basically these kind of contract are, if you are supplying drugs, you are supplying pistol to the public, these kind of contract come under the category of legal contract. If we see the example of the gambling, in Goa gambling is legal. So if you are doing gambling in Goa, it's fine. If you are doing gambling in UP, or if you are doing gambling in Delhi, so this is your illegal contract, right? On the further we move to the execution. So on the basis of execution there are three types. One is your executed contract, where the both parties have fulfilled their obligation. So suppose, let's say a contract to buy a car by B, paying cash and instantly deliver the car. So here the both parties have fulfilled their obligation. One party have paid the amount and another party have delivered the car. So the both have performed their duties. Now, if we talk about the executory contract, these contracts where the both party has not fulfilled their obligation, they have to fulfill in futures. So let's say this is your example. D agreed to buy B's car, the cycle, by promising to pay him cash on 15th July. B agreed to deliver the cycle by 20th July. So in this, the contract is not performed by the both parties. When both party under the obligation to perform their duties in future, so this kind of contract are known as executory contract. Now we have the partly executed or partly executory. So a contract which one party has fulfilled an obligation but another party is not. So if we talk about the partially executed, means one party have fulfilled their obligation, another party have not fulfilled their obligation. So this come under the category of partly executed. And partly executory, where the one party has fulfilled something but another party have not been fulfilled the obligation. So let's see the one example over here. A sell his car to B and B deliver the car, but B yet to pay the price. For A, it is a executed contract, where is executory terms on the B. So अगर हम यहाँ पे देखेंगे तो B की साइड से executory है, A ने तो अपना काम कर दिया है. Now the last one is your on the basis of liabilities. If we talk about the on the basis of liability, one is the bilateral contract. A contract which both party commit to perform their respective promises is called the bilateral, contract, where the both party need to perform their liabilities, perform their promises. So this is come under the bilateral, when where the both parties are involving, right? Of A, let's say we have an example. A offers to sell his car to B for 1 lakh. On the acceptance of A's offer by B, there is a promise by A to sell the car, and there is promise by B to purchase the car in two promises. So where the promises by the both parties and they have to perform their liabilities. So this is known as your bilateral contract. And another is unilateral contract, where the one party is bound to perform their obligation, another party is not bound to perform you know the duties and the obligation. So let's say a unilateral contract is one-sided contract which only one party has to perform his promise and obligation, and party has to perform the promise and obligation to forever, right? So let's say A want to get his room painted. He offers rupees 500 to B. For this purpose, B says to A, if A have a spare time to next Sunday, I will paint your room, right? So there is a promise by A to pay 500 to B. If B is able to spare to paint A's room, however, there is no promise by B to paint the house. So there is only one promise which is given by A. So here is A bound to do the things. So this is known as your unilateral contract. That's all from my side. We meet in soon for the next lecture.